The Joint Committee on Administrative Rules will come to order. If you would like to testify on a rule set on the agenda today, please fill out a testimony card and turn it in to a sergeant or any of the clerks up here. Will the clerk please call the roll?
Chair Wozniak.
Here.
Representatives Johnson.
Here.
Wartz.
Here.
Farhat. Carter.
Here.
Senators Waino.
Here.
Bayer. McMorrow. Tice.
Here.
Runstead. Mr. Chair, you have 4 representatives and 2 senators present.
All right. Do we have a quorum for the minutes from the last meeting?
Yes, sir.
And we're good, right?
Yes, sir.
Okay. Senator Bueno moves to adopt the minutes on the March 12th meeting. There being no objections, the motion prevails by unanimous consent. Okay. As a reminder.
One more, too.
Okay, what do you got? Oh,
April 22nd.
oh yes. Okay. We also moved, Senator Tice moves to adopt the minutes of the April 22nd meeting. There being no objections, the motion prevails by unanimous consent. All right, as a reminder to committee members, any action by the JCAR committee shall be by concurring majorities of the members from each house. That means that 3 representatives and 3 senators must vote in the affirmative on any motion and for that motion to prevail. Today we'll be hearing testimony on JCAR rule sets 2539 and JCAR rule set 2540. We'll begin today with Aaron Shore and Adam Fracassi-Ware. If you both could come up and have at it.
Thank you, Mr. Chair. Thank you, committee members, for having us today. I'm Erin Shore, for any of you that don't know me, and this is Adam Fracassi. We're the Deputy Director of Elections with the Bureau of Elections. I think, even after decades working in Lansing, this might be a first for me, getting to be in front of JCAR. So appreciate being here today with all of you. I know Adam has a few prepared remarks on the 2 rule sets, and then we're happy to take any questions.
Good morning, and thank you for having me here today to provide testimony on the administrative rules. Like Aaron said, thank you I think this also is a first for me as well, for coming before JCAR to testify. So we have 2 rule sets. We've got the rule set regarding the Lobby Act and the rule set regarding the Affidavit of Identity challenges. So I'll take each one in turn. My plan was to essentially just kind of say why and what they would do and the purpose and why that we decided to go into the promulgation process. So I'll start first with the with rule sets regarding the Lobbying Act. So this rule set was begun upon request of an individual who formally submitted a request under the Administrative Procedures Act pursuant to Section 38, which allows a member of the public to request the department promulgate administrative rules. And the lobbying rules, the proposed lobbying rules, are based on 2 interpretive statements that the department had issued dealing with gifts surrounding lobbyists and what they are and what they are not allowed to do. So the question that was asked of us in the 2 interpretive statements asked the parameters around when a payment can be provided related to a gift in order to bring it below the gift threshold without violating the lobby law's gift prohibition. And it also asked whether a public official could provide reimbursement either in advance or after the fact, in whole or in part, in order to kind of offset that difference between the cost and bring it into compliance in any way to bring it down below the Act's threshold. So what this rule set would do, the lobby rule set, would codify the department's conclusions in those interpretive statements. It would provide that public officials may not reimburse lobbyists in whole or part for the value of the gift that exceeds the Act's thresholds. So stated differently, if there is a cost, if the threshold is $50 and the value of the gift is $100, a public official may not pay that difference between $50 and $100, either in advance or after the fact, in order to bring it down below that gift threshold. A public official cannot provide the difference of a cost of the item in order to reduce that value of the item or a service that is being offered in order to avoid that gift ban threshold. The rules also clarify, the proposed rules, also clarify that if a public official pays consideration of equal or greater value, that it's not a gift. So stated differently, if a public official purchases something and it's equal or greater value, that does not meet the Act's definition of a gift. If you're buying something in the normal course of action, a ticket, or if you're providing a service for an event or something like that, that's not considered a gift under the Act's definition, under the Lobby Act's definition. It would allow exchange of services as well. The rule set would allow exchange of services so long as the public official provides a service of equal or greater value and it's related to that public service. So for example, appearances at a conference or speeches. Again, that does not equate to a gift under the proposed rule. We're specifically clarifying that. And the rules also provide a greater definition and a process for determining fair market value. So we've said this is how you provide that framework, and this is what it means to be fair market value, how you figure it out, and who has the burden. In this case, the lobbyist filing the report has the burden of determining fair market value when submitting that report and demonstrating fair market value. So turning next to the second administrative rule, the Affidavit of Identity rule set. This rule amends the department's existing administrative rules to provide timelines and clarity on submitting challenges to a candidate's affidavit of identity and based on the contents that are in the affidavit of identity. Public Act 650 of 2018 added new requirements that prohibited a filing official from certifying the name of a candidate to the ballot if that candidate provides a false statement on the affidavit of identity. Where we see this the most in the election since that bill was passed in 2018 and signed into law is related to campaign finance statements. It's related to allegations that candidates owe money, a fine, a fee, or a report, and that the filing official should disqualify the candidate from the ballot. In those elections, both our office as well as city, township, and county clerks have received a number of challenges against the affidavit of identity itself for a variety of issues, many of them coming very close in time to the date that we have to certify the ballot, and it puts our office as well as local clerks in a difficult position. I can say that we have received challenges literally the day before we have to go to the board and certify the ballot, and it puts it in a very tight timeline. So what we did is looked to Section 552 of Michigan election law. Michigan election law has timeframes for submitting challenges to a candidate's petitions, but it is silent as to the affidavit of identity. So in promulgating these proposed rules, what the department did, what we looked at was essentially taking that structure that already exists in 552 and just expanding it to everything. So what the rules would require is it would require that challenges to the affidavit of identity be submitted no later than 7 calendar days following the filing deadline. Again, that's in current statute for petition signature challenges for nominating and qualifying petitions, and that any response would be provided to the challenge within 7 calendar days of the candidate receiving the challenge. So once the filing official sends it. It would allow the filing official to have discretion to accept a challenge upon a showing of good cause, and the rules do define good cause, largely based on the definition of good cause that is already established in the Campaign Finance Act, and it would require that challenges be notarized, again, taking that from Section 552 of election law, which currently mandates that challenges to nominating petition signatures be notarized as well. So again, when we were drafting this rule set, we tried to mimic the structure that is already in place that everybody is currently used to, both clerks, filing officials, and candidates as well, to align the statutory timeframes and the requirements for the affidavit of identity. So that's all the prepared remarks I have. So again, thank you for being here, and I'm happy to answer any questions.
Not now.
Rep Farhat. Okay, good morning. Thank you, Chair. Good morning, everyone. I have a couple questions here to understand this rule set here on the Lobby Act, right? And let's just start here. So fair market value is basically the value of it at the date. So let's say I'm a municipality and I'm going to use tickets because we love talking about tickets. I own the stadium. Wayne County owns the stadium, right? The stadium authority owns the stadium. The university owns the stadium. They don't pay anything for those tickets, arguably, because they are the entity by which administers those tickets, right? How then are you determining the value of those tickets? That's number one. Number two, you mentioned that if your presence is of equal value, you can go essentially for free to conferences and things like that. I want to come back to that point. Actually, let's enter one first because it's gonna be a longer question. Let's go to one first. Yeah.
So the first question, what I would say is, when you're looking at fair market value, I'll stick with the tickets. What the rules do is define a primary market and a secondary market. So in that instance, the ticket being, if it's being sold directly through.
Yeah, but there's no resale. Again,
Yeah.
these are the region's box. You don't sell these. Not for sale.
Right.
Can't find them
So
anywhere.
fair market value would look at what is the price that it goes to. So I'll give it to as an example. I'll cite something how we do this currently with the Campaign Finance Act in determining fair market value for contributions. If you were to sell that ticket to somebody, what would you sell it for? Is the lobbyist giving a public official a discount because of their status as a public official?
But if you're an
That's not
economist,
fair
you'd
market
say
value.
something's cost whatever the market's willing to bear, right? And if in that instance the market's bearing it for $1, right? I guess I don't understand. And the market is me and you. I'm not understanding how what you're getting at here again, how that's solving an issue, which I think is transparency or accountability of elected officials. But I don't know how it's being solved here with this rule set. Personally, I think what instead it's doing is driving a wedge between folks who have the means by which they can get access to these events and thus not work, because there are material benefits, I'll tell you, and those that don't have the means, I think. And I think that's what these rule sets are accomplishing here. And I'll be candid, we see many public officials, including the public officials who may have drafted this, at these events because they are of means. I think my point is, how then do you reconcile the fact that you have these tickets, right? Which again, it's not really a big deal for me. The bigger issue is this rule set does not remedy the reality of which that everyone that is independently elected comes from a different background of lived experience and a different appreciation for certain abilities to network. These basically just box out those that have coming from different economic backgrounds, if we're being honest. This completely says, yeah, you're eliminated from this process, and if you have the means, you can buy these tickets. Because again, this doesn't remedy the fact that it's not making it more transparent. That's one, and number two, you're just picking and choosing who can really go by pushing it to those that are either reliant on outside funds or independent wealth. I mean, how are you reconciling that? How do you, I guess, see this rule set as a remedy to that problem that was asked by the initial person years ago?
I would say, Representative, the department does not have a position as to who can afford to purchase tickets or who cannot. That's not the purpose of the Lobby Act, frankly. The purpose of the Lobby Act is to lend transparency to transactions
Yes.
between lobbyists and lobbyist agents and people who make policy. Mm-hmm. In that spirit, we have introduced this concept of fair market value and the definition, and I think there are clear markers of what the public can see. In your example, if I'm the city of Lansing and I own the Lugnut Stadium and we're giving away tickets in a box, that has a very different value than if I'm the University of Michigan and I'm giving away tickets in the Regents box to a, early season game against Texas when I'm the defending national champions. Both wonderful instances. I would encourage you to come and see the Lugnuts play when you have a chance. That will be under your gift limit, I can guarantee it. But it's not the purpose of the Lobby Act to take a position on who can afford these tickets or not, and that's not anything this rule set speaks to.
Correct. And so then to the point that it's supposed to speak to you, so the Lobby Act is supposed to regulate interactions and bring transparency. How does this make it more transparent? I guess is my question. Where me personally, I know it's maybe not under the purview of the rule set, again, making it disclosable or making it more, how is this making it more transparent?
There has been some line of thought I have heard among public officials that you're correct, that because the entity that perhaps owns the stadium or the box doesn't pay any extra for those tickets, that they can invite people. And I think these rules and our previous declaratory ruling attempt to speak to the fact that there clearly is value to those tickets.
I just think, again, even on the interaction of your, the presence adds value. So, like, if my presence and I'm doing a book signing at an event, right, that adds value, even if there is inadvertent gain for a public official to be there. I think, again, all of these are attempting to get at the real issue of transparency and of regulating lobby interactions, but fall short, in my opinion, at doing what I think the people of Michigan want us to do, and that is disclose these interactions, make them public, disclosing the need of individuals, the interactions so other people can find them, right? But again, I think this rule set here, I personally have reservations on it because I think it falls short on bringing the transparency people are asking for, and it just creates a system where those that have the means can adequately get these tickets, can find ways to curtail the system, they can find ways to go ahead and use whatever means they have, and then those that don't are boxed out of it entirely, and it just drives a further wedge, I think, between good the people that are trying to do their job and people that can't afford to do that type of 5 to 9 job, right? We know these jobs are relationship jobs. The 5 to 9 is just as important as the 9 to 5.
I appreciate their representative and understand with rules we can only work within the bounds of the statute that they're based on. If you're interested in looking at statutory changes, we're happy to have a conversation.
Sure, thank you.
Senator Tice.
Good morning, and thank you for your presentations. I have questions on both rule sets. So just to tap off what you were just speaking to, what's the statutory language that you were referencing that prohibits legislators from being able to pay for the difference between the fair market value and our acceptable gift limit?
That's part of the proposed rule. The statute's silent as to that. So
then what is the reasoning behind it? If the answer is that this is our gift limit, and as someone who's really not into sports anyway, I mean, it's not a big deal for me, I'm just trying to understand the mental process behind it. So if there's no statutory language that's guiding it, then what is the ethical language and the transparency issue, perhaps, that would prohibit what has been done historically since time immemorial from being done now? Why would you prohibit that?
I apologize. That reasoning was in our declaratory ruling where we walked through this, and that is in effect even regardless of what happens with these rules. Do you happen to have the declaratory ruling, Alessa?
Not printed out, but.
Okay.
I am curious, even with the declaratory ruling. Okay, then what was the baseline for that determination?
Are you able to speak to that, or should we follow up with the information?
If you need like 2 minutes.
Absolutely.
I can come speak to that.
Do you want to ask another question while she's pulling that up?
Sure, but it's on the other rule set. So the other rule set is speaking to the affidavit of identity. One of the things we're required to do is say that the candidate is required to say that they don't have any current debt owing. Generally, they rely on a different individual to verify, in fact, that that's the case. What happens if they detrimentally rely on that information, file, what's the process? I can see here that based on someone's determination, they can decide to let it slide or not, as long as you correct it.
So the only thing that the filing official under the rule set is allowed to, can have flexibility on is whether or not to accept a challenge upon the showing of good cause. So I'll kind of speak to the process just first on how our office handles it and how we recommend all filers. When folks come in, the very first thing we ask when anybody comes in and files the affidavit of identity, we always encourage you to do it in person as well, so we can do this for this reason, is we will ask you if you have anything outstanding. We will check it as well before we even allow you to file it, because we don't want to have to disqualify somebody for exactly what you're saying, and we will resolve it all beforehand.
But what if you were mistaken?
the statute mandates that we have to disqualify.
So I ask you whether or not there's anything owing. You tell me, no, there's nothing owing. I put in my affidavit of identity. You find out there is in fact something owing that neither of us knew ahead of time. Now you disqualify me and I have no opportunity for appeal.
You can appeal directly to court, yeah.
Ouch.
Which takes how long?
Which takes how long, you said? I will say that in election litigation, it moves very quickly, so we can have final decisions within a day or two.
That seems,
It takes 2.5 years.
you should have some place to appeal to if the candidate was not the one at fault in this process. They should absolutely, within this rule set, should have listed an appellate process.
Unfortunately, the statute doesn't allow for that. There has been some conversation. I've been with the department since 2022, and particularly that filing year, we had a number of high-profile individuals that were rejected from the ballot, and there was some conversation about perhaps allowing more flexibility in the 2018 law. But right now, as the statute stands, there is no way to correct something once you have already made that misstatement, even if it was not through the candidate's fault. They have already made an erroneous statement on the affidavit of identity, and the statute does not allow any way to fix that.
So is it that the statute doesn't create an avenue, or is the statute prohibitive of?
The statute, so the statute doesn't specifically create an avenue, but it says by using the word shall disqualify, how we've interpreted that is we don't have flexibility with that. When the statute says, in section 558 specifically says the filing official shall disqualify for making a false statement. We don't believe we have flexibility to be able to even do it via rule, to say, well, shall unless the following, because that's not specifically in statute. So because it's kind of because of that.
Yeah, and I think the department has an openness to talking about what a process for curing those affidavits of identity might look like, particularly in cases, as you mentioned, where the filing information or filing official provides faulty information, or perhaps a designated record keeper or something, and there could be documentation of that. I think the department's open to those conversations, but right now the statute just does not allow curing it once a misstatement has been made on the affidavit.
So just for the record, the trip to court is going to cost potentially tens of thousands of dollars in order to appeal something that wasn't your fault to begin with, for which you detrimentally relied on a professional on the other end that you were handing your ID to. So I would very much appreciate if we could have that conversation, and perhaps there's legislation that needs to be introduced in that process. But I have concerns about the way the process is happening right now, as has been evidenced in history. Did we have more information here? Thank you for letting me take up so much time. I appreciate it, Mr. Chairman.
Hi, Alessa Bose. So you asked which the statutory language in the Lobby Act. Well, could you just ask the question again?
Again, I don't generally do the ticket stuff, so it's not an issue for me, but historically, what has happened if there was a ticket where the fair market value exceeded our gift allotment, what was allowed to happen is that the candidate was, or the elected was allowed to pay for the difference on it. And so I'm wondering what the thought process was, or the statutory difference was that changes what we've done historically that now prohibits that from happening.
Sure. So the question hadn't been asked to us about that until last year, when we got a request for a declaratory ruling or interpretive statement, asking that exact, is this process a violation of the Lobby Act, yes or no? And in our interpretive statement, we decided that it was, and that was based on the Lobby Act's definition of gift in MCL 4.414. And as Aaron said, the entire analysis is it was interpretive statement issued on August 8th, 2024 to Robert LeBrant, and that's published on our website.
I can follow up and share that statement with the committee.
Yeah, but essentially, we looked at the Lobby Act's definition of gift, using that statutory language, to decide whether that interaction where a person pays the difference in the ticket price removes that transaction from gift or not, and determine that it does not.
So if I can jump in, I can read the definition of gift as well. So gift means a payment, advance, forbearance, or the rendering of deposit of money, services, or anything of value, the value of which exceeds $25. It's adjusted under a different section in the lobby law, unless consideration of equal or greater value is received thereof. So that's where this largely has been, that's what we were looking at, because you've got the advance forbearance language in the exact statute, in the exact definition of gift there.
So am I wrong? Sorry, am I wrong? Unless consideration, that last part of the sentence seems to say, yes, you can compensate for the difference.
Consideration of equal or greater value.
So you're saying you can only take it on the whole, is how you're reading that?
Correct.
Yes.
Thank you.
Just for a question on your process, how do you determine what is going to be a new rule in your department? Is it by committee, by fiat? Or how?
That probably depends somewhat on whether we're talking about the election side of the house, the transportation side of the house. There are things that, in elections, we have had fewer rules. There haven't been very many promulgated over, frankly, the last several decades, and there have been a number of areas where we're relying on department guidance. And so one of the questions we look to as we come toward the end of this secretary's term was about what might be more appropriately in rule rather than simply in department guidance. On the driver and vehicle side, it's a little different. There are things that need to be updated periodically and haven't been touched in a period of time. But we have lawyers that look at these things.
Reports.
Thank you, Chair. So I'm new here to the legislature, so I'm trying to wrap my head around some of this. So I have a couple questions, if that's okay, Chair. My first question is, so who requested this rule set change or clarification?
So it started with two interpretive statements. One was from Robert LeBrant, and then the second was from the Michigan Association of Health Plans, I believe. Okay, I couldn't remember if it was healthcare providers. So that's what this framework was based on. And then as far as the section of law, the APA part that I referenced, that was directly from Robert LeBrant as well.
Okay, and then what is the penalty, I guess, if someone violates this? Is that listed in here? Did I miss that?
If someone goes
Right.
above the gift threshold,
Yeah.
that's directly in statute. We don't create a new penalty or anything like that. So the gift prohibition is under. Let me pull it up real quick.
Toward the end.
11, I believe. It's MCL 4.421. It deals with the penalty for gifts. And again, we don't change this with the rules, nor do I believe we can. But what the statute specifically says is that a person who gives a gift in violation is guilty of a misdemeanor if the value is $3,000 or less, and shall be punished by a fine of not more than $5,000 or imprisoned for not more than 90 days or both. And then it goes on and adjusts if it's higher and lower. But that's, again, it's straight in statute. It's section 11 of the lobby law.
Okay. Well, I guess my concern here, and it seems like all we're doing is pushing, I get the idea of transparency, but when we look at even our own governor, for example, and the amount of money that she has spent in traveling, and there are accusations made that it was on taxpayer dollars, that since come out that said, no, it wasn't on taxpayer dollars, but it was used by a dark money account. And, for example, a trip that she took recently cost, I think it was nearly $300,000. So $285,709 for a 7-day trip in September of 2023 to Japan, for example. So where's the accountability in that? And that's being funded. That this isn't addressing any of that, correct?
Representative, we can only speak to gifts regulated by the lobby law. I don't know any details of how the governor finances her travel.
Well, according to the news, it was funded through a dark money account. And I guess my concern here is all of it seems like in an effort to create transparency, people find the loophole and the way around, and all they do is go through funneling money through accounts that there's no accountability for. And that maybe that's what we should be addressing more, is scrutinizing that process and making it that things have to go through actual campaign finance accounts and be accountable so that everyone can see that. And all this is doing is, when you start scrutinizing this tighter and tighter, is pushing people to use other accounts that have no transparency or accountability whatsoever.
I know the federal decisions that were made have been pretty clear that there can be almost unlimited amounts of money spent and get around our existing campaign finance laws. The Secretary has been very happy to support greater transparency of dark money accounts and supported the BRIGHT Act bills that were introduced last session and some of them reintroduced this session. We'd be happy to support those and to have a conversation about more tightly regulating dark money in Michigan, and I'd be glad to partner with you on that.
Thank you.
A
Rep.
question.
Johnson.
Thank you. Sorry about that. Thank you for being here in this presentation. Following up with Senator Tice's question about an affidavit of identity being filed, and you find out it's incorrect, but when they went to find out if they have any fines or problems, the Bureau of Elections said you have no problems. What is the penalty with the Bureau of Elections when they're wrong? And they give misinformation, not intentionally, but a mistake is made? Because we know what the penalties are on our side, but what are the penalties with Bureau of Elections? Are there any?
I'm not aware of any.
Yeah, not like directly in statute. I will say, though, I'm also not aware of a situation where the Bureau has done that, because we're looking at the exact system that you're filing on. Yeah.
Okay, well, that's, in an ideal world, you guys never make mistakes, and that's wonderful. And if that can be the case, that's great. We have the best state in the nation, which we do anyway. But we all know that that can happen. Banks make mistakes. Governments make mistakes all the time, and all sorts of departments. The IRS makes mistakes. So it's not above, you're not above making a mistake. I think we need to talk about fair balance here with, if someone is held to a standard of the information came out later, Bureau of Elections finds it out after they said there is no problem. And again, this never happened to me. It's not personal to me, but it could really happen. And there's no proper recourse. And taking it to court can be a very lengthy thing. I know we all hope, but everybody's got their stories of how long things have taken in court.
Certainly, and it could be a local filing official as well. As I mentioned to Senator, I think we would probably prefer to look at some way to cure these things rather than simply adding additional penalties. I was in a very different role in 2018, so I can't speak to what the writers of this section thought they were fixing, but I think they perhaps made something that was just a little bit stricter than it needs to be.
And I would agree with you, that's probably best, but this is incomplete if it doesn't deal with both sides of possible mistakes.
Could you go through the process of amending a report? Do you have a process for amending?
We have a process for amending reports, but not an affidavit of identity.
No, I want the campaign report. How do you amend that? Do you know?
I believe you would do it. You do it essentially the same way where you file. You just, when you go in and use the system, you'll be you essentially select the report and you just make the change that you want to make. So you, instead of filing a new report, you would be picking the one that you want to change, and then you've got to go in, and if it's you're adding a contribution for example, or something like that, you would pull the report up and essentially say, all right, I've received this contribution, it's now $50, it was on this date, and put it in the appropriate report, and then you've got to carry the balance through as well. So if that, obviously, if you're taking more money in, or if you missed a contribution afterwards, you've got to just adjust the balance going forward. That's at the end. So I don't know if that answers your question or not.
Yeah, I think it does. Just do it online is what you're saying, right?
Yes.
Yes,
And-
or through your, if you use a system, like if you use a vendor, I know some candidates use like a third-party system, they may have a different requirement, but it ultimately has to come to us through ours, regardless of how you do it.
Do you accept a third-party report?
So when I say a third party, I am aware of a couple of companies that are out there that will kind of act as your treasurer and do the reports, and then they will give it in, basically import it into our system. So that's what I mean. But at the end of the day, it comes to us. But I can't speak to if you use like Aristotle's, a company, for example, that I know of. If you use them, I don't know the process that they would have. I can just speak on our system, which most people use our system versus another company.
And how long do you have to file an amendment?
There's no deadline to file an amendment.
Okay, next year, year after?
Whenever the information comes
Yes.
to your awareness.
Okay.
Yep.
And do you review the previous report and the current report, the amendment?
Yes.
Okay, and what is the process for that? I mean, are you looking for something in particular, or just say, oh, it changed?
So we're looking to see what the change is. In general, is this like we missed a contribution, or is this was the original report zeros and now you're disclosing things? Those are two ends. Most of the time, it's when you're going through, you're closing your accounts, or whatever. If you're going through end of month check on your end or something like that, you find things that you miss, and it's one or two transactions for the most part. And so we're looking at it just for the same way that we would be looking at the original. Is this money coming in from an acceptable source? Is the money going out of the account? Is it to an acceptable source? Meaning, like, is it a corporate contribution? Is it a prohibited contribution? Or is it on something that you're not allowed to spend money on from your account? Is it going to a personal expense, for example? So we look at them the same way. The comparison with each other is really just what's the volume difference, like things like that. Like, what is the type of transaction that's being added?
And how do you communicate that to the candidate or the official? That you've observed and you have questions on it?
We
Or do you
issue.
make a determination without notifying them?
Well, so if there's an issue with the report, we go through the notice of error and omission process, and that's all under the Campaign Finance Act. It mandates us to review it, and if we find an error with the report, so for example, if a corporate contribution was received, we will issue a notice of error and omission and then work with the candidate to resolve it. Or we may even issue a notice of error and omission to ask for more clarifying information. We have to issue the E&O under the Campaign Finance Act, but sometimes it's this is what we're thinking, and we might ask you for documents, and it clears it, and everything's fine. Sometimes it may require an amendment just to fix the issue as well. So it just kind of depends on what the transaction itself
Are
is.
you serving the notice of errors and omission online or by mail?
It primarily goes to the treasurer through the email that they provide us when the candidate registers. It goes to the treasurer's email. And then if we do get to the point, we have sent them via mail as well.
In lieu of that, can you re-amend an amendment
Yes.
before the notice of errors and omissions?
Yes.
Or after that also?
Yep.
Anyone else yet? Yes, Senator.
Thank you. I'm sorry, I missed a couple of things when we were first speaking. So when you notify a candidate that they are in violation of their affidavit of identity, how do you verify the notification?
So the first thing we do when we have, so we don't follow the error and omission process for an affidavit of identity. I just want to be clear with that. The error and omission process is specific to the submitted statements under the Campaign Finance Act. So when we're reviewing affidavits of identity, the first thing we do is we send a letter to the candidate that says, this is what we think is going on. Give us information, tell us otherwise. We have had instances before where we would send the letter out and say, we think it looks like you owe us money, and the candidate would come back and say, I paid it, here's my receipt, and we clear it essentially, and we move forward. So we do ask for the candidate to try to give us something. Maybe there's something we're missing. Maybe there's something that the local filing official was missing, you know, like Rep Johnson indicated, mistakes happen, right? So we do, first step, work with the candidate to try to figure that out.
I'm backing up before that, though. So we've got a hardcore 7-day deadline from point of notification. How do you verify that an individual has, in fact, been notified? You've sent an email out, therefore it's okay. Like, what is your perception of what that notification verification looks like?
I apologize. Sorry, I misunderstood your question. So generally, we send that via email. If we don't receive a response, we have also sent via certified mail with a signature requested. So that way we can verify that it's been received.
Does your 7-day shot clock start at the point of what you mailed out, or when you received back a verification of signature?
It would be whatever date it was received is when the 7-day clock would start. So if I send it via certified mail on May 1st, I don't even remember what today's date is, to be honest. Not enough coffee yet. So if I send it out May 1st and the signature card says it was received May 2nd, the 7 days would start on May 2nd, because that's when the candidate actually received it. And then that's what the provisions for good cause are in there as well. If for whatever reason something happened and you didn't receive it, the filing official would be able to extend that timeline upon the showing of good cause. Not receiving it would be one of those reasons.
So again, with the appellate process, because we've seen a lot of politicking on both sides for this, if the individual doesn't use their discretion and decide to go ahead and extend out the time frame, what's the appellate process for the candidate in the event that they believe they'd shown good cause, but it's not being received, not being recognized as such?
So to extend the deadline to respond, you mean?
Well,
Because that's the good cause only applies to extending a deadline to respond to a challenge.
okay.
So is that your question?
So-
Is what's the appellate process for that?
How do you keep politics out of it if what we're doing is talking discretion? The individual at the other end has, at their discretion, they can make the determination as to whether or not good cause has been shown. Do you then have to go to court to show that they accepted this as good cause for candidate A, but not for candidate B? Is that another, do you understand what I'm saying?
Yes, thank you.
Okay.
The rules define good cause specifically to try to avoid that. So that way it's if, one of these things are taken, that is good cause. To try to avoid any inconsistency with applying good cause. So that's kind of the first piece that I would say. And again, that definition of good cause is taken directly from the Campaign Finance Act as well, to say if something happens, all of those things. So that's the first piece that I would say. As far as from there, it does not have a specific appellate remedy.
It seems like it should.
That's where I would come back to kind of what Aaron had indicated. The statute, we don't believe the statute allows us to do that.
I fundamentally disagree with that perception if what you're talking about is somebody's discretion. You're either going to give them discretion or it's absolute. Those are two completely separate things.
So if you're talking about discretion for timing, that's different than the discretion for making a decision. The
They can
filing official does not have discretion on making a decision. The statute's very clear that it's you shall do X, Y, and Z.
But we're giving them discretion on that decision.
No, the rules do not give the rules only give the filing official discretion on whether or not good cause is there to extend a deadline. That's
Okay.
it. It does not give a filing official discretion to make the underlying decision. The statute says the filing official has to do that.
So they use their discretion. They don't extend the deadline. They should have extended the deadline, given the language required for discretion. Where does the person appeal? I feel like I'm talking in circles here, so I'm sorry.
I mean, they would appeal to court
Yeah.
at that point.
So another $20,000. Okay.
Right?
Go ahead.
This only puts timelines in place. It doesn't change anything about what the process for appealing whether you should appear on the ballot is.
No, I get that, and I agree with you that we need to work on that.
Okay.
Reports again?
Yeah, thanks. So let me just ask, going back to, I guess, a question Rep. Farha asked at the beginning. Let's say I need to take a trip. I've been invited to speak. The company's going to give me a private jet to fly. Maybe the cost of that trip is on their jets $40,000, and they tell me the ticket that I need to pay is $900. Is that allowable?
I think we would need to look at the details of the circumstance and for what reason you're traveling. Is that someone affiliated with a group that does lobbying? What exactly are you providing in terms of your service on part of this trip? We did have a recent, I believe it was a declaratory ruling in response to the Detroit Regional Chamber talking about the value of conference tickets and the value that legislators provide there, but that did not work through a rubric for every sort of circumstance to figure out what value a public official provides at a conference or in another circumstance. So I think there would be probably a high bar to show that a legislator was providing enough value to offset a $40,000 private travel or, private jet. But I don't think anything in these rules would change existing law around that. We would need to look at the details of the case.
So again, I go back to the hypocrisy of all of this is that this is what our governor did, only she used her, again, a 501c4 account, and it was approved. And she didn't even go and speak. She just went and visited her father in 2021. And so it's rules for thee, not for me, is what this seems to be from your department.
We don't approve expenditures from 501c4 accounts.
Again, but that's, so you want to enforce these rules, and then it's just pushing people over.
We are required to enforce the lobby law rules.
Referring to Rep. Wertz and Senator Tice's comments, with regard to discretion in decision, it seems from the hypothetical that we've just gotten that you describe a discretionary answer or ruling.
Mr. Chair, the reality that we're in is that there are different rules associated with different types of expenditures. Certainly the legislature could look at trying to make more consistent how public officials fund various types of travel and other endeavors. That would be a statutory change and not something that we could do through rules.
Okay. Any other questions? No. Senator?
Thank you, Mr. Chair. Mostly for a point of clarification and to build upon previous arguments, the department can only enforce the statutes that are on the books. Is that correct?
That's correct.
So a lot of the conversation about travel and expenses and disclosures in 501c4 is really under our purview. I know there's legislation pending in the House on the BRIGHT Act that would address not all, but some of these issues. I also know that a number of us, I think on both sides of the aisle, have concerns about the Citizens United ruling from the U.S. Supreme Court and what that has done towards campaign finances and the explosion of dark money. So I would say just from our caucus, there's a willingness to work on these issues, but that comes from our body. If we want to tighten up the rules around expenditures and disclosure, that's our purview, not the department's. Is that correct?
That's correct.
Thank you.
So we've got a deadline coming up in about a week. Is it better to be early, late, or don't file?
Definitely not the last one.
Okay.
Early to the extent possible, and I know we have our team prepared to help anyone who's working on filing. It's a new computer system and not perfect, but we stand ready to help any filers.
So, can your department be called directly or
Yes.
for instruction? Okay. Right to you.
Right to me. I have to ask my children for help with technology at this point, so I won't be the one providing the tips, but
The moving thumbs.
I will
yes.
make sure you get help.
And another question?
May I just have clarification on the gifts? It's $79 limit per interaction, correct? And is there a total for that?
I can follow up, but I don't know the exact dollar value off the top of my head just because it fluctuates, but it's,
For this year, it is $79, and that just comes from the definition of what is a gift. So it's not considered a gift under the lobby law if it's $79 or less.
And is there a per year
Well,
limit also?
if it's not a gift under the Lobby Act, then the Lobby Act's regulation of gifts just doesn't apply. If it is a gift, then it's prohibited to be given to a public official by a lobbyist. Yes, and meets the other elements of the definition of gift in the Act.
I don't think.
Is there a yearly cap also?
I don't, that's what I was just double checking.
So-
Something about monthly or something in like the
Yeah.
range.
So the Lobby Act has caps on like other
Yeah.
financial transactions between lobbyists and public officials, yearly caps, but
Yeah, like food and beverage, for example, there's a monthly limit, but that's different than a gift. Gift is, I believe, and if I'm incorrect, we'll follow up, but gift is governed by the specific item, that's 79 per thing. All of the other like monthly, yearly, caps are under Section 8 of the Act, and that governs like food and beverage, those kinds of things.
and the $79 gift cap is in any 1 month period. It's right in the definition of gift in the Act. Yeah. Thank you. Sorry, it took me a minute, but.
They're taking another bite of the apple.
Okay, sorry, just one more. What's the food and beverage limit per month?
What is it calculated at now? Yeah, it gets adjusted with the.
Oh, yeah. I'm not sure. We might.
Can we follow up?
We might have to follow up. It's adjusted every year based on inflation, so we can't just look at the statute. We'd have to do the calculation.
We have it on a sheet, so we can provide the whole sheet. It's got all of the limitations, so we can send that to you.
But
I think for all the questions you're getting, I think it'd be great to have that information too.
Absolutely.
Yep.
Senator Bear, you have any questions?
No. I've already been asking questions.
Okay. Senator Tice, one more time? No? It's all right, thank you. Okay. Senator Bueno? Nothing? Okay. We're all done? Well, thank you for coming in with your testimony, and really appreciate it. I'm sure we're going to have more clarification as we go forward in the next couple of weeks, particularly. So early, late, or don't file, right?
Always
Preferably file. You can always amend it.
Yes.
And I know I have a couple of items to follow up
And
on.
amend.
Yes.
All right. Well, thank you. Do we have any cards? No cards. Okay. Senator Bear moves to excuse absent members. There being no objections, the motion prevails by unanimous consent. There being no further business, the meeting is adjourned.